Why did you not show up for the hearing?
The day before the hearing, I was in the hospital. He removed access from me to do payment. I didn't know it was removed. I got a document that says I was a prior tenant.
Defendant does not deny that she was in default of the payment terms of the lease.
And so you don't dispute that you weren't paid?
No, I don't dispute that.
I'm going to rule in the matter. Case number 26992LT. Is counsel here for the plaintiff?
Yes, Your Honor. Good morning. Kristen Mattern on behalf of the plaintiff, P77548.
Hey, good morning. And ma'am, you are Brittany Jones, is that correct?
Correct.
Okay, good morning. Okay. And let's see here. All right, Ms. Jones, this is your motion to set aside default judgment, is that correct?
That is correct.
Okay, and I've reviewed your motion. You indicated in the motion that there was a problem with paying the on the web app or app that was agreed to on the lease, and that's why payment was not made. Is that right?
That is the reason why it wasn't made. Under my lease, there is no clause that they can remove the payment regardless what the issue was. So that was a lease violation that you cannot remove a payment. I didn't know there was a clause about the terminate the tenancy, but sorry, I don't know legal matter very well. Obviously, I'm
Well, this is your motion. This is your request
right.
to the
Okay,
court.
so
Hang on, we can't talk at the
sorry.
same.
Sorry.
Okay, so this is your motion, your request to the court to grant, set aside the judgment that was entered in this case. So in order to set aside a default judgment, there's two things that need to be shown. One is good cause of why you did not appear for the hearing where the default was entered. And two, that you have a meritorious defense, that there's some legal reason why the plaintiff would not have won at that hearing that you did not show up for. So as to the good cause, why did you not show up for the hearing?
The day before the hearing, I was in the hospital for acute pyelonephritis, and I was unable to attend a hearing. I did call multiple times to your clerk, letting them know that I could attend virtually, but I was incapacitated. I don't know if you're aware what acute pyelonephritis does to your body.
Okay, so
And I
we don't.
provided documentation.
Hang on just a sec. We don't adjourn cases just based on a phone call, because if we did, everyone would just call and say, I can't make it because I have a disease. And so I don't see that you filed any affidavit showing that you were hospitalized or any medical record showing you were hospitalized. Did you do that?
I provided the actual documentation that I was hospitalized the day before on the actual motion.
The day before what?
The day before the actual hearing.
Before the hearing that you did not show up for?
No, when I filed the actual the motion for default. I filed the actual document that says that. I didn't know I should submit it before that.
Okay. All right. Now let's go to the issue of meritorious defense. So this
Okay.
was a complaint alleging that you hadn't paid under the lease. Had you paid everything under the lease?
I paid November, and then we were behind on December and January. And then on January 16th, he removed access from me to do payment. I didn't know it was removed. I got a document that says I was a prior tenant.
Okay. And so you don't dispute that you weren't paid?
No, I don't dispute that. I dispute how it was done and how my lease states I should be able to pay, and then everything that happened. The day before the hearing, I did ask, not the hearing, but the day before I filed for the actual motion, I did ask the landlord if he would file a stay so I could move. He denied that. and the plaintiff's attorney stated I never contacted anybody, and I have. I contacted you guys multiple times, not being able to attend and trying to attend virtually and get, but there was multiple emails, not emails, voicemails.
Okay, okay. All right, anything else you want to tell the court?
Yes. The plaintiff's attorney filed a counter against my motion. Can I state the reasonings how I feel that
I want to just hear, what is your basis to support your motion to set aside the default? Are you moved out of that place now?
No, I am going to move out though.
Okay, all right. Anything else?
No, then.
Oh, all right, Ms. Matern, response?
Yes, Your Honor. As the court's aware, we filed a written response opposing the motion on the basis that the defendant has failed to establish good cause for failing to appear for the hearing at which the default judgment was entered, and also to challenge her alleged meritorious claim underlying the default or the judgment itself. I won't restate everything that the court is aware of in the pleading or in the filings. But I will note, though, Your Honor, the defendant does not deny that she was in default of the payment terms of the lease. The timing that she claims she wasn't available to make payments online is well after the default occurred, and the failure to cure the default had already passed as well. And as we noted in the response, there were more than one way to make payments, and Ms. Jones never made those either in the proper time. And the other piece, Your Honor, is we just in terms of the logistics here, we did submit order for eviction. The court entered that order for eviction, and we have taken steps to have it served and effectuated. But I believe that the officer who served or who posted a notice related to the next, step for that eviction was told by defendant that there is a stay in this matter on her order, of which I'm not aware. We've not received any records of that. And I cited in the brief the court rule that would counter that unless this court had entered a stay at any point, preventing the judgment of possession from being effectuated. It cannot be denied. And so I just want to make that clear, Your Honor. We have attempted. It's my understanding that a notice has been posted Monday, and that that defendant told the officer that a stay is in effect. I do not believe that any is. And so to the extent that this court is considering the motion at all, I believe it would only be able to consider the motion as to the judgment on monetary damages, and that the possessory judgment should be allowed to proceed. And to the extent that the court is going to, I guess, deny the motion in full, then I would just like it clear on the record that we are able to continue to proceed with the eviction action according to the court rules.
Okay, thank you. Ms. Jones, anything else?
Yes, on all of the counters, I would like to state for A, again, the plaintiff's attorney stated that the motion is untimely under MCR 4.201N. The motion was timely due to the 14 days, which would set it on the 13-day post-judgment. Even if it was past the 14 days, the judge at his own discretion did have the actual ability to accept a reasoning for missing the hearing due to my case. I was medically unable to attend due to my condition because it completely incapacitated me. B, she stated the defendant's motion does not meet the grounds for relief under MCR 2.612. Under the motion that was filed, it's clear that it shows the judgment was entered while I was incapable of attending is well deserved. I was incapacitated, and my meritorious defense is clear that my landlord removed access without knowingly and unlawfully makes payments, which does fall under this claim. My lease clearly has nowhere in a clause to give authority to my landlord to remove access to make rent-ready payments.
Ms. Jones, it sounds like you're reading your motion.
My response, yeah, because I can't.
I've already read that, so I don't need you to read it.
No, you didn't read this response. This is something that I have never submitted.
Okay,
all right. She submitted this the other day.
Okay, you can continue.
Okay, it says the lease is this is a violation of the lease, and which hereby puts the landlord also at fault for some missed payments, which makes the post judgment inaccurate, which does make my defense grounds of relief. My landlord should be held liable for this lease violation. This also falls under fair housing law. The landlord initiated intimidating nature by interfering intentionally with my ability to pay. By telling me, the landlord, that they have an eviction order at the sheriff's office when the courts told me that there was not one. He intentionally told me that in a message, and there is a text message that I can provide that he stated that he intimidated me back and trying to tell me that the court did so, and I filed that motion that day. And it says, moving on to C, and about the issue of a stay, the plaintiff's attorney intentionally tried to virtually serve me with a eviction notice that wasn't signed by a judge, which was served on the info serve thing. I don't know what it's called. Then physically in the mail, served without it being signed by a judge. Then intentionally still filed after a stay was filed on May 6th to have an eviction notice placed on my doorstep with an officer, which was very embarrassing and scary. The landlord also did default to correct his own issues within 30 days. The landlord was given notice in writing of removal of acceptable payment method and never corrected it. And the lease term 18 states that default by landlord in the event of any alleged default in the obligation of the landlord under this lease, tenant will deliver to the landlord written notice specifying the nature of the landlord's default, and landlord will have 30 days following receipt of the such notice to cure such default, or in the event of the alleged default cannot reasonably be cured within 30-day period, to commence action and proceed diligently to cure such alleged default. This default was where they removed my access. Yes, the plaintiff states that there's other ways, and it was to provide payment to them by a money order, but they don't accept money order. They cashier check.
So Ms. Jones, I think you're kind of far beyond the issue that's before the court, which is whether there's good cause in a meritorious defense. And so I'm going to rule in the matter. If you had a grave illness and were medically incapacitated on the day of the hearing, that would be good cause. I don't find that you have demonstrated to the court that you were, other than by your own statement. So as to the issue of good cause, I think there possibly is good cause for your failure to appear. However, with regard to the meritorious defense, I do not find that you have raised a meritorious defense. You were in default under the lease. You've acknowledged that. And so the judgment was appropriately granted in this matter. I'm not going to set it aside. There is no stay of eviction that's been granted. So I'm going to, Ms. Matern, if you'll submit an order to the court denying the motion to set aside default, and I'm going to allow an additional 5 days for the writ to be effectuated. So an order of eviction may enter after we'll make it June 8th. And so that way, Ms. Jones is on full notice that if she doesn't move out by June 8th and remove all her belongings, that the court officer or sheriff can remove her belongings. And that way, that'll just give some guidance to the server as well. So that's all for the record.
Your Honor, just for clarification, the court entered an order of eviction on May 7th, and we are trying to have that effectuated now by the officer. So are you ordering that additional time will be granted for her to move before that can be fully?
Yes.
Okay.
Yes. The order of eviction is being extended to June 8th.
Okay.
Okay. All right. That's all for the record. Thank you.
Thank you, Judge.